Hello, I'm back. Hi. Okay, so I was here before and I didn't realize that nobody could hear me. So thank you so much, Shauna, for letting me know that I was muted. Now, before I go too far with it, I'm just going to ask a friend if he can jump on and let me know if I'm working. Can you please check now? New stream. This is what happens when you have like nearly a year off streaming. So, and even my StreamYard plan has lapsed. So we've got the StreamYard logos. Let's just represent and be grateful that StreamYard allows us to stream for free, which is really cool. So I'm in the middle of watching, hopefully you can hear me, in the middle of watching or starting to watch today's day 29 of the Karen Reid retrial or re-persecution. And I am not up with what actually happened today. So I don't know all of the shenanigans. I have just heard, I've avoided X as much as I can, and I've heard that it's a bit of a shit show. So I'm both anxious and excited to get to it and to watch it. So if you're watching and you can hear me, can you let me know? So can you hear me? Hopefully you can hear me. I'm just going to wait until somebody says yes, you can hear me before I keep going. Otherwise I might have to like jump back out and come back in again. Yay, Shauna, you're amazing. Okay, so don't go anywhere. Just while you're here, let's just make sure that while you can now hear me, that you can hear.
Jeans.
Yes.
If we could go back to full frame.
Can you
Have you
hear
ever heard a phrase, knocked out of your shoes?
Yes.
what as
What have
well?
done his shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
What's the form of the question?
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
You can take that down.
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay.
Thank you so much.
Move for the condition of that photograph, Your Honor.
Yay.
222.
Permission to display
Thanks, Chris. I appreciate it.
that. Is this the rear
Buy
photograph that we
something
were just talking
nice.
about?
Yes,
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
correct.
Did the subject vehicle photograph that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you.
I'm so nervous. I mean, the car
You
and
were asked on cross-examination several
Randy
times about the weight
are
of the
ruined.
Hybrid 3 arm. Do you recall that series of questions?
Yes,
You were asked how much lighter the Hybrid 3 arm was than the static estimate arm, correct?
correct.
I want to make sure we're clear about this. The Hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. That's not. Is that a physical arm? Your touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid?
How funny. Every time this guy reminds me of a cartoon character. I don't know if anybody else has ever picked up on it or said something, but and I just can't put my finger on who it is, but I can see it in my head. He just looks so much like a cartoon character, like an existing one, not just a generalized cartoon character, a cartoon character that exists. So if anyone knows what I'm talking about, let me know, because I just cannot think of it.
hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the final number he landed on.
Sustained. Ask the question. Stop striking the end.
Does 11.86 sound right?
Yes.
Okay. Let's use 11.86. You have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38, just in raw numbers?
You're looking at just the difference between the two?
Subtract
Okay.
9.38.
2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86.
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Sustained.
Is 23% smaller or not or larger than 26%?
Sustained. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
0.21.
In percentages?
21%.
Thank you. Was the hybrid 3 arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
Yeah.
Weight differential of the hybrid 3 arm.
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3 arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you were?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour.
Yes.
Did you also do a test with that hybrid 3 arm, contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those 2 tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it'd be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
Crash Daddy
I'm
School.
going to ask you if you wouldn't mind to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm.
Walk
as an
us through
assumption
it,
of the weight
Crash
of the arm.
Daddy. Come on.
Okay. Your Honor,
Understand?
may I have a pen and paper to write?
May I approach you?
Absolutely. I have my pen and paper ready.
I have a
Thank
pad
you.
here, too.
Let's do
Whatever's
this.
easiest.
Please. Please walk me through it.
If you assume the mass of 11.86, that's the statistical arm weight, and you assume the
11.86.
V for velocity is 24 in miles per hour. Don't care about the
V
units, doctor.
is 24.
Just assume 11.86 and 24.
11.86
Can you
and
calculate
24.
this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the
Okay.
result of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared is 576.
How does it know that
In
off
this
by heart?
calculation, do you always use the exponent first? You always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
It is 576. Unbelievable.
How many decimal places do you want? Nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
No wonder I'm struggling on one and a
That'd be
half.
3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm.
Okay.
That's being transferred.
Understood. 3,415.68. Is that right?
Correct.
And that was at what mile per hour?
24.
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what question.
Can you calculate, do the same calculation using the 9.38 pound arm that you actually used in the testing for the mass?
Yes.
And can you use the velocity of the actual test you did at 29 miles per hour?
Okay. And same thing, not worry about units.
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24-mile-an-hour test is the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29-mile-an-hour test, as it compares to the hypothetical 24-mile-an-hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Potentially.
Sustained.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29-mile-an-hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29-mile-an-hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend
Not over the weekend, no.
after you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right?
Sustained.
Was that a surprising estimate, 11.8 to you?
Well, I don't know that it was surprising. I don't know what you're.
When you engage in accident instruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just out of thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you can make it up out of thin air. You have to find a resource, a reliable, vetted resource. True.
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that a 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test, and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is,
It's sustained. Ask the question again.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216-pound man. Where did you get that from so you can be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize a 9.38 pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated for use of that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, In our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile. Isn't that fair to say?
Correct.
And there is, in fact, the 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference to study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, so let me ask. You have one paper, one study to support that is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me, do you?
So I'll take out the commentary. Can you answer that question, please?
Sorry, can you repeat the
You
question?
have one paper. Give me a name, an author, one paper, one study that supports using a 9.38 arm, 50 percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm gonna allow that.
I'm not confused. I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage
So
off
if
the
you
top of my head.
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds?
Okay, close to 9.38.
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11? Is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony. 11 pounds. Your prior testimony, right?
Yes,
You testified for under oath in this case, didn't you?
correct.
And you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm. Based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Objection.
Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Objection.
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so
Well, we just did the math, didn't we?
yes,
Okay. And you used a calculator to help you, didn't you?
I did, yes.
Calculator works.
Yes,
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
correct.
And then you divide it by 11.86. Divide 2.48 by from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with the statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
Didn't ask you. I'm asking if you would agree with that.
Can you repeat the question, please?
So ask the question.
Does the arm weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
We're going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct. Yes.
Yeah. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints?
No.
You didn't explain it to the jury that there's a difference in weight matters?
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass, so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force of the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
Why would he?
You didn't overstate the mass. You didn't use an arm that was 14 pounds. That would have created the opposite illusion, right? You use a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm. And you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummies arm for these types of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and person's body? Are you aware whether that exists?
I'm not aware of the studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your world, in your profession, that suggest or state that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No.
Okay, so.
Let him
no comment,
answer.
Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs where you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the tail light.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard, isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
No, I haven't seen it yet, Shauna. So I'm literally watching this in real, like live in real time, as in yeah. Haven't seen that. This is all fresh. So I'm nervous.
The hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure.
It's
Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in. Much different than a hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier,
So glad I'm not alone.
it creates an easier tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those.
No, the most appropriate test, Brennan, is to paint the taillight blue and roll into it at 2 miles an hour. That's the most appropriate test.
Those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than a crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
I would not either.
When you
And I am
used
no
the
crash study.
crash test dummy in test A and B, that was the 5'9" dummy.
Yes.
It doesn't matter.
When you consider tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt,
It was actually the same.
Don't know if I recall the exact size, but I think one of them might have been extra large.
and then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used
Oh
medium
my,
sweatshirt, yes,
what?
Yes.
because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt. Yes,
I think it was more or less just what we could get our hands on.
we had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head
Why
what
does
sizes
that
were on each
matter?
test.
Okay, can we show a picture of A to remind Dr. Wolf? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes,
So the blue ones you use for test A and B, correct?
correct,
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
correct,
And then when you use Randy and brought him into the scene, you used the extra large, the gray one.
correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct,
The extra large you put on Randy was new.
correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Have you ever had clothing sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes
Oh
more easily.
no,
Did you do
Stop
any
it.
type of analysis on that whatsoever?
stop it.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Stop it. Whether it's been in
Does
the
it matter whether or
dryer?
not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first
No,
time
because it doesn't
ever
happen.
that you've done this type of analysis and offered an opinion in front of a jury on this.
Specific to impacting an arm with a taillight, yes.
Before you
Correct.
decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
Oh,
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you had studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you had never done before?
oh my,
And that you did
wow.
absolutely no study
Stop it.
on fabrics or any of
The jurors, like, I don't know. I have to have a look. I don't know who was in court today. Was Jess Machado in court? Because Turtle Boy wasn't, was he? I'm going to have to watch his live later because I think he's live now. But anyway, I really am keen to know what the jurors' kind of reactions, responses, facial expressions, demeanors were today. Surely, please, for the love of the traveling Mary, the jurors can see Yes. Please. Yeah, I don't know. Oh, but it's just, this is crazy. And yeah, anyway, let's go.
Other people's analysis on fabrics and cutting, did that concern you?
No.
So you were comfortable just coming in with no experience whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. We worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
The other one testifying, giving opinions to this jury, yes?
Yes.
The other one asking them to rely on your experience and training, true?
Correct.
The other one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion. Putting aside Dr. Welcher or Dr. Rentschler, you have responsibility for your opinion, don't you?
I would generally agree with that. Yes.
Generally?
Yes.
When wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes. And again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in the subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. I remember writing in a report, it is significant to note that the injuries have been classified as abrasions, and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis.
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm going to see you in sidebar.
Sidebar. All right.
Would continue to drag the arm until the body either was thrown or spun off. Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
So can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side, yes.
So what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
What?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
But he wants the taillight to actually hold on, turn on, puncture it,
Correct.
and move with it straight through.
Slower and the vehicle pushes and drags against the arm.
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand. Before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, so get significant more damage to the tip, significant more damage that taillight shatters, hits and moves forward into arms. Parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of the taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so if you would like to agree with me, you can disagree with me. Can the broken taillight push the arm? So it contacts.
I just can't stand the way he speaks to him. I can't handle it.
When you were showing those photographs today regarding test F, now you use Randy in test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $100,000, $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate studied crash test dummy, is he?
I don't agree with that because we use that type of dummy in all different types of tests.
There's an H395 MPED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag. When
Right.
That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might...
Yes, of course. I remembered last night. Yeah, but it was the first day of Turtle Boy's trial today too. Yeah, I can't wait to catch up and see how that went for him. Thanks for reminding me. Cool. I'll watch his live later. Thanks.
Show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet. You used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those timeframes, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet. You used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
And the street has hard concrete and has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
And the photos that you were shown today on redirect examination, did the defense show them to you during the direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
It's a piece of taillight.
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before?
It's also completely angled.
Can you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
And finding taillight fragments on the clothes after a collision, that's not unique, is
Up on
it?
your bed. Good boy. Up
No,
on
it's
your bed.
possible.
Well, according to this, it's probable, yes?
In this test that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
No, incorrect.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please?
Okay, thank you for letting me know.
Analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I want to know why. I wonder why. Is it still like that? And is it just my audio? And is the court audio okay? Maybe it's only choppy when I talk over the court, which is annoying anyway. Let me know. Thank you so much. I'm so grateful I've got you here, Shauna. I'd still be talking on mute if it weren't for you. So, thank you. All right.
I don't know if it was on the concrete, might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please?
Sustained.
Did you talked about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well.
She is sustaining a lot of the defence's objections, which is refreshing, surprising. I mean, I won't get excited, but okay. Thanks. Yeah, okay, let's go.
When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
11 of your report.
I think I lost an exhibit.
Hannah's notes is a massive folder. I love it.
Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Beyond the scope, Mr. Brennan.
A few more questions, Dr. Wolf. You showed us holes in Randy's sweatshirt from Test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit arm?
Yes.
What about the holes?
Excuse me, sir.
Okay, let me just vent about this, and I know it's been talked about and vented about, but I haven't vented about it. But the freaking shirts in the plastic, you know, as if they're like, I just can't. Why? Why have they put the shirts between two pieces of plastic? Okay, let's go, Shauna. Let's go.
Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. You see more than one hole in the back of Mr. O'Keefe's sweatshirt.
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just one more. If I may, Your Honor, you were asked by Mr. Brennan, give me one name, very dramatically, of someone.
The objection sustained.
You were asked to give me one name
What?
to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. You remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm, over the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
I'll allow it.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort. No.
So as you sit here,
Exactly.
any idea what the size of those pieces are?
I couldn't tell you as I sit here today. No.
No idea if they're a foot long?
Gotcha. So the objection sustained.
You were asked when shown this picture if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were?
So the objection's sustained. He said he doesn't know the sizes. That's the end of that. Mr. Jackson.
I realize he said he doesn't know. He was
That's
asked
the
questions.
end of that, Mr. Jackson.
Wow.
Do you have Mr. Wolk, do you have the picture of the tin? The TIN, tin, little round tin.
It does sound like the same
Did
10.
you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments. Yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing arm?
It's going to move with the vehicle until it separates.
In your testing, how long did it take the hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again. About
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, right?
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that you saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the buses, the test buses?
Destroyed.
Are there any follow-up questions?
Okay, go ahead.
Okay. Yeah, and I'm not surprised. The jurors must be. I don't know if I can survive a recross. Look how, oh, okay. Oh, okay. Oh, here we go. Oh,
It would mean the broken taillight's going at a faster speed than the arm. If it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, not the source.
Dr. Rentschler, do you agree with that?
Objection.
So I'm going to allow it.
of course you are.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, we're talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize it is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Do you agree with
I'm
that?
going to allow it.
Wow, I heard that. I need to approach. Like, they are getting so annoyed. It's just insane. Like, it really is insane. It's a farce. It's a farce. Is this where the jury gets sent out? What are we up to? 2:46.
I'm going to read this one more time, okay?
Okay.
Oh my God. The crime. It's a crime.
If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please.
No.
And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, he's going to be pushed, like this says, by the arm, by the broken taillight.
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take our morning recess. We'll see you in about 20 minutes.
You rise for the jury. This way.
Okay, here we go. Is Alessi putting gloves on or taking them off? God, I just love this man. Like, he is everything. Well, he's got
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie. In this regards,
I'm just going to slow it down, sorry, a little bit.
questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked, the first document, and I want to get the specific title. These 2 documents are from the criminalist file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
I also just it eats me up is how Bev is also so obnoxious. Alessi is so angry and is so frustrated, and her okay. It's like, oh, you actually don't care. She doesn't care. It gives me goosebumps. It's so horrible. It's just the worst.
And may I see that, please? Thank you. Okay.
That is the back of the hoodie, Your Honor. If I could please have the next mark in order exhibit for identification.
Oh, completely.
Exhibit ZZZ, Friday identification. Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay.
What?
I can't tell entirely from ZZZ, but if that's your argument,
Wait.
why? For question appears to support that.
Your Honor, may I?
Exactly. I have I actually have the exhibits. I have the photos of the shirts. Long sleeve. That's the front. Move. If this is going where I think it's going, this. Is this the back of the shirt? Anyway, okay, let's keep going.
I have the exhibits marked for identification back from my argument.
Okay.
Thank you, Your Honor. Thank you, Madam Court. Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line
Okay.
of question was going to be asked was when Mr. Brennan pulled the case out.
Okay.
She has got to be kidding.
Go ahead, Mr. Leslie.
Thank you, Your Honor. So to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely, Your
Mr.
Honor.
Leslie.
So here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get to back to this in a moment. But I would like to do it and certainly entertain any of your Honor's questions, but in a logical order.
Sure. So I'm not. What about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay.
What about the jurors and lunch? How long is this going to take? Excuse me, defense attorneys, but how long do you think it's going to take for you to keep trying to defend your client? You know, like, how much longer? We just can't have this constant defending of your client who is presumed innocent until proven guilty. We just can't.
All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So, Mr.
He wants to get the flow back. So stop interrupting him, Judge. Just let her speak.
Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said when you said obviously cut by the criminalist? Do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note.
So just 2 years ago. Just 2 years ago. Uh-huh. So suck that, Bev.
Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one to my knowledge, not put into evidence. Not
Look at how he's actually shaking. I'm keen to watch this. And I'm assuming that everybody that is watching this has seen it anyway. This is it, right? This is the back, but inside out. From last trial. Like he's visibly shaking. He's visibly shaking. Crazy. So that's the one from last trial. The exhibit of the back. Anyway, okay, sorry. Let's come back.
This is the one that clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to why, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-218-4, analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to point out to me where it says where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various. Let me just get a check on this, Your Honor. I'm not.
Right. Mr. Brennan, you should come up and look at this.
Thank you.
No, Mr. Brennan can sit that off down. No.
And I'm
So this one has a statement.
yes.
All right, so this is why.
Oh my God. See, Brennan just he is such a snake. He knows exactly what he's doing. And how he sleeps at night is a mystery. How he sleeps at night is an absolute, I just don't get it. I do not understand how these people can do this. I just don't get it. I don't get it. And can you imagine? Like, I often try to get inside of Karen's head, and it's impossible. Unless you're Karen, or you've been through anything even remotely close to what Karen's going through. And how she sits there every day in court with composure is like beyond belief, because I just don't know. I don't think I could do it. I would break down. I'd be crying. It's unreal. It's unbelievable.
Can I get the check? Pardon me? Right, but if I can, Your Honor, I want to clarify this. Yes, I do. Well, let me just make sure I get.
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, just a second. It may print the wrong page. I can do it, but Mr. Wolf, you print the back. And Your Honor, are you comfortable using the computer or the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now. printed, we wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
The way she has carried on with the grave concerns, the way she carried on over the ARCA text messages, the way she carried on about the $20,000 that was paid to ARCA post the second trial, the way she has carried, like that in and of itself was just. She's so nonchalant about this. She is nonchalant. She's like, oh, I don't even want to know where this goes. I mean, I've really tried to avoid X. I'm assuming nothing comes of it and that it's just onwards and nothing to see here. But
Go ahead with your argument.
If I may, Your Honor, I'm advised it'll take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminal.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
Thank you, Madam Court Reporter. Sure. Here's another document, chain of custody document. Well, Mr. Brennan is reviewing that. We may head to Madam Court Reporter, the chain of custody document for these, and ask that he mark as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
Do you need this, Mr. Lessie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and Georgia Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, Mayor, thank you.
I still do not have ZZZ.
All right. Thank you. Okay, go ahead, Mr. Lessie.
come on, Mr. Lessie. Show me what's
So,
done.
Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case. Ms. Hartman, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, the Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right. So let's move along from
right,
that.
That's what, and I'm going to come back to this.
I just hate how she interrupts them. I just hate it. It's always, right, let's move along. How long are you going to be? How long is this going to take? Don't expect it to take much longer. Move along. Next question, please. She's just always underlining them. It's so horrible. Honestly, to that, this is twice in under a week that he's had to motion for a mistrial with prejudice because of the DNA misconception, which was intentional by Brennan as well.
Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalist as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial.
Yes.
The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial.
This is the antithesis of a fair trial. So true, Shauna. Use the Scrabble King that the dictionary fears. The antithesis, and I like how Oliver holds his hand. This is the antithesis of a fair trial. Fantastic.
Miss Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear. The more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Why do they keep stopping to look?
And so Your Honor, my brief review.
What was the standard?
Your Honor, my brief review of the lab.
What's that? What's that? What's he looking at?
My brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Someone must have done something there. Someone must have said something. It's not funny. It's not funny. But it's like he's such a knob that I just anyway.
And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about.
He just referred to himself in the third person.
Holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt.
This is bull. He did it on purpose, and this is him making up for it. And Bob's going to agree, isn't she? She's going to say it's remedial and it's okay. We're going to agree. We're going to stipulate, and we're going to tell the jury that Mr. Brennan made a mistake.
The parties agree the holes were made by a crime lab technician. This was done inadvertently, but should not have been asked. The court should strike the questions and the answers, and you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt, and the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion, Mr. Lessie. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B, 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this.
What I'm going to do is I'm going to instruct the jury that I'm corrupt, but Mr. Brennan has been paid over $500,000, will be earning over $1 million to re-persecute Karen Reid. But none other ADAs in Michael Morrissey's district attorney's office wanted to actually bring this to trial because it's a complete sham. But yeah, what Mr. Brennan tried to do is he's tried to mislead you by confusing you when he was cross-examining Dr. Wolf. He brought the sweatshirt up of Officer O'Keefe's and implied that there were holes from the rash. Now, he didn't say that, but that was his implication. Now, that was actually incorrect. It was not for an accident that never occurred anyway. We're just making it up. There was no collision. We just like to pretend there was a collision because what happened was Brian Albert and Brian Higgins murdered Officer John O'Keefe, but we have to protect them. We have to protect them. So what we're trying to do is re-persecute Karen Reid and put her in jail for it because, you know, she's just got a flat ass from Fall River. So she doesn't matter. So if you can just bear with us and just overlook the fact that Mr. Brennan was caught intentionally misleading you guys, we hope that you enjoyed the lunch. We can come along now. If you could just avoid social media and don't like emotive reactions, facial expressions, etc. while you're in the jury box. Okay, if you could just do that and comply with the corrupt court that is the Norfolk Superior Court, that would be lovely. Okay.
I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Lessie, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates.
Your Honor, Honorable May 18th, when the defense filed a motion to test. So those that's the probative date.
So May 18th?
Yes.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further?
It's just so bizarre. It's just so bizarre. It's just so weird.
You want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
All right, so I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up because that's what
Okay.
happened.
Yes.
Yes.
Yes. Yes.
Thank you. So that's number one as part of the stipulation, and then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation,
Sorry.
but just as Your Honor said. With regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview.
Lovely. It was so nice to have you with me. Thank you.
Your Honor, honor about time.
So I do say that when I say misconduct. So rewording it just a little bit. Mr. Brennan asked Dr. Wolf about holes in the back of his sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th. So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi. Okay. All right. So it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms. Carnett during the course of her inspection and sampling of the circular made So I can just read that all out and just say, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist Ms. Carnett during the course of her inspection and sampling of the sweatshirt are made. It's probably needed that way anyway. All right, let's bring them in, please.
Judge, this is a housekeeping matter that the sweatshirt was taken out of the plastic sheeting. It might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something, maybe we have it marked. But we don't need to do that right this second.
May I approach Mr. McDermott with exhibit
Yes.
B?
Thank you.
All right, thank you. I'm sorry. Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
Thank you.
Counsel, this is exhibit 223.
In your honor, I would hold it as your honor begins to read. Is that consistent with your honor's explanation?
No, I want you to hold it up with the back. You do that first and then I'll give you. All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right, so you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return to Mr. McDermott, or the court officer.
Yes, court officer.
Bear with me a moment, Your Honor. I'm going to put on the.
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapis out of here?
She's here. She's not next. I'm going to call up. John T.
For just the measurements?
Your Honor, if I could show the exhibits from Ms. Hartnett or the cuts, along with the next second instruction shows the cuts we made by Ms. Hartnett.
Well, I say it, and I'm going to tell her what they are. So.
Court is in session.
All right. All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay. Thank you. Why don't you go ahead and put it back in the bag? Cool. All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunch isn't here, but I think we'll, Mr. Unetti, and sampling of the sweatshirt. So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunch isn't here, but I think we'll... Mr. Unetti, your next witness, please.
Okay, step up, face forward, and raise your right hand.
You solemnly swear the evidence before the court and jury in the case now here to be true.
E-D-E-M-A-N.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location.
I started out in Los Angeles and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start? Forum investigations.
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
What were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd, I believe I arrived about 5:30 at 34th Avenue.
Okay, when you say June 3rd, we are talking about last week.
Yes,
correct?
last week. Yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
Can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if you could, Mr. Wolf, could you display the photo of the front video that's already in evidence? With the
Yes.
And what exhibit number is that, Mr. Wolf? 46. Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door. Up those 4 steps, I guess. Then, if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
And then there are obviously the 2 garage doors.
The 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wolf, put the lights on. May I put you with this one?
Yes.
So I placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the 2 car doors to the garage.
Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Did that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you previously testified to?
Yes, it does.
I would offer that one.
All right, can I see those, please, sir? I ask you to take that down.
Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break. All right, so we'll fix that during the luncheon break, Mr. Nettie, to what I said. All right, so can we get Dr. Lapisado in here? We'll do a very brief voir dire with her.
And you're gonna step up, face the court, and raise your right hand.
Do solemnly swear the evidence you give before the case evidence is the truth, the whole truth, and nothing but the truth, so help you
I do.
All right, good afternoon, doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those 2 areas. And if there is support or methodology in Dr. Laposada's resume to point to exactly where that is. Okay. And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Laposada. That's spelled Laposata.
Dr. Laposada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Laposada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation.
Okay.
Do it as briefly as you can with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, then we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? And I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist would say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes,
Are you familiar with some or most of those publications?
absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At
graduate
the
school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds
Courses that I've taken.
that you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage in that case? Did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes,
Did you in fact testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was injured, or well, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death has something to do with the motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes,
Is it to a reasonable degree of scientific certainty?
yes, it
Is
is.
it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regards to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Good afternoon, Dr. LaPosada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Now, beginning when I took my board, starting in 1983,
And what did that entail?
it entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks, and it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, yes,
And
I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you?
Well,
Completed your boards.
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there's our lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. LaPosada, I just wanted to ask you about the report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically. No.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston Federal Court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
Well, they have the same kind of dog jaw.
So
They're,
you
ta-
would say
they're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office. And there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand.
No, you
In
don't.
this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes,
I have my list here. Should I read
that's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuroppathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. Thank you. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was part of the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in the case Cromwell versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you're the qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Lapasada.
No, you're welcome.
So can I just ask Dr.
Yes.
Lapasada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Any questions based on my questions? All right, you are all set and actually step down, Dr. Lapasada. We'll
Yeah,
get to you sometime this
all
afternoon.
set.
Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Your Honor, it's very brief.
Okay.
It's eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog? Was it another animal? Was it another source? Was it lacerations versus abrasions, things of that nature? She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these 2 subjects that's before the bench right now, than somebody with Dr. Lapasada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do not think that Dr. Lapasada has articulated the experience the way it's been summarized. She could not provide any specific training.
I can't stand him. I just can't stand him.
Other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis.
Why is he so worried? Why is he so worried? If they know it's got nothing to do with Chloe, if they know that it's not a dog bite, if they know, then there's no need to mislead the jury and say that there's holes in the sweatshirt from road rash, which is exactly what he did, and he knew what he was doing. That was not a mistake. They just let it go. They just let the defendant defend herself, and then they would cross-examine with dignity, with honesty, and he'd poke holes in it, and he'd say, you know what? But instead he just stops. He tries to stop the defense from defending.
As far as being in a training, seminar, or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition.
And just while I'm here, like, I'm getting really frustrated. I don't know, like, where is Higgins? Why are we not calling Brian Higgins? Why are we not calling Brian Higgins? Why are we not calling Brian Higgins? If somebody could actually give me a legitimate answer that makes sense to me. Where is Mark Betterow? I know he was on with Mike tonight on the Young Jerks, and I am excited to go and watch once I've finished watching the trial. Where is Brian Higgins? Why is he not being called? Like, stop it. I'm scared. I'm worried. I'm worried for Karen.
Relative to dog bites. If we look at the standard Dr. Russell employed, Dr. Lapasada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, And she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. LaPosada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion
She doesn't need to be an accident reconstructionist.
whether or not the wounds are consistent with broken taillight. There's nothing we see on her CV. There's
No, but she does have common sense, mate.
nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. So based on her testimony and absence of being able to provide any education,
No. Your case is improper. The case that the Commonwealth has brought is improper against Karen Reid. There is no collision. That's correct. You're wrong.
she should not be able to testify about either of these two matters.
Okay, thank you.
Okay. She was, Mr. Brennan suggested, well, she's only been qualified in one court, another court. The federal judge that was handling that case qualified her as a dog bite expert.
Yeah, a federal court, a federal judge qualified her as a dog bite expert. Judge Bev Canoni from Norfolk County, a federal judge.
In that case, that is not a small thing. That, as a matter of fact, it's a very big thing for Dr.
It is a big thing. Yes. Yes, it is.
LaPosada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. LaPosada brings much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. LaPosada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites. And I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right, thank you. All right, I'll get your ruling as soon as I can. So we're going to stop back up at 2:20, and I expect to go straight through the rest of the act.
All right, for the court, please.
Deep breath.
Close back to session, may be seated.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right, so my rulings are very similar that they were this morning. So first of all, on the Darbert analysis regarding Dr. LaPosada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the
Stop. Oh, wow.
Darbert requirements have been made, specifically not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. LaPosada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. LaPosada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now, moving on to the testimony regarding not being consistent with a motor vehicle strike. I find that Dr. Lapasada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all, in some regards significantly, like I said this morning. So on page 17, that first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. And Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in. And the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Lapasada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of the, there's no PowerPoint with this, Mr. Jackson, right?
There's no PowerPoint.
All right. Do you intend on displaying any of these photographs?
Sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes, I have to go through it now. Of course.
All right. So you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in.
Wow.
And, right. We're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right. And I expect what I would do is I will go through that will take me a good amount of time. I will go through the part of her initial analysis that will not include any of the photos, but I may be organized to actually go through the course ruling. It's very specific. And I would be as
okay. So let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay. That was not objected to. There's a big difference. So we'll deal with this tomorrow, with the photographs tomorrow. Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way? Okay. And there's a motion on Dr. Rentschler. We will give that. I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. This jury, you can tell just by looking at this jury, they're fed up. So.
Yeah, they are fed up, you know. They really, I'm going to timestamp that. Where are we? 5:47, 46. They are fed up, Bev. They're really fed up because it's a joke. They're not fed up because the defense are taking up their time. They're fed up because they're at this trial. They're trying to make sense of the misconceptions, stuff that doesn't make sense, the fact that Hank Brennan is trying to pull the wool over their eyes, the fact that John O'Keefe's arm looks like he was attacked by a dog, the fact that the tail light, even if it were to push while he got hit, isn't going to leave those linear lacerations or abrasions or whatever we call them. The jurors are fed up because you have to finish at 3:45 every day, that you have half days, that you clearly are biased and side with the Commonwealth consistently, that you're rude, openly condescending to the defense. That's why they're fed up.
John, the only thing I want to put on record is, with regards to the court ruling, I do want the record to reflect that is obviously it's going to be the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Lapasada. They have the report, and all the discovery was done in March 6th, 2025. That's document number 45.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
She just doesn't care.
I just need to know when I made it.
You just made it.
I made it ish.
Okay. Okay.
The point is,
Go ahead, real quick.
the point is, the Commonwealth has not explained the delay.
So,
Making this motion. They haven't, and we're playing by the same rules, Judge.
no, so the basis of my ruling was not late disclosure. Okay, late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They had since March to object. They blew the motion in only time. And then they could have just before
right.
just before Dr. testifies, and now we're sort of sandbagging this and making courtrooms against us. So I wanted you to be imminently clear.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during proffering testimony. There's no foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify that the defense could object if the foundation weren't properly laid. So bring them in, please.
I'm speechless. I really am. Okay. I think I'm going to go, guys. Everyone, I mean, there's no one here anyway, but that's okay. Metaphorically speaking, I'm going to go, guys. I'm going to watch this a bit later. I have to head off. Cool. It's great to be back. Feels so good to be live again. And I am excited. I will be live again very soon. Now that I'm back, I've got some momentum going. It was great to watch some of that with you and to watch the most controversial part. But there's something controversial every day with this case. It just never stops. It's just unbelievable. And I'm serious. I'm worried for Karen. I really am. So I'm going to go and watch Turtle Boy and the Young Jerks, which is exciting because I want to know what Bettero has to say about today. Very keen to see what he has to say. And I want to go and see how Turtle Boy went in his trial. All right. Thanks, everyone. Have an awesome day, night, evening, wherever you are. If you haven't subscribed, please subscribe, hit the like button, and follow me if you like. I'll be back soon.